Hello 101.5 FM Kumasi Adum. Arishma me mamu nyina ajo. Enyumre ye men na mahodo so nsema ye nsa kan de bra mu kase boy na radio stations ahodo so. Ghana ne amanone ene ye de ato peacefmonline.com. peacefmonline.com.
Na ensema ye de suma numu de di makotene bi ene say Omampanyi dada His Excellency John Dramani Mahama a ye petitioner review application a wode ko Supreme Court no atemwafo si enyina so no enimram enu nti wo mabato agu.
We dismiss the instant application as being wholly without merit.
As the court pleases, we are grateful to the court.
Dr. Dominic Ayene mrebi etwemu na woye Ghana otemuafo mesremo Ghana omei atemu adwumadie no na wo sha wono ne osoafo sha atenten ne so abedi ekire na eno aban lawyer panyini ene osoafo sha atenten ne so na no ena enne naseme kopie court no Supreme Court atemuafo ahye ne say na some predetermined agenda sasa atemuafo atire adwemu no wo mafa adwene dada ene wo mu siginaye no wonko pacho.
What we can do for your client is to let him go back and purge the contempt. Yes, he should tell the people that he's very, very sorry. What he did was wrong.
Kumasi Jedifo Ediato Mampani His Excellency Nanado Danko Kufuadu Animsa Commissioner, our Dasepsa Nono Wonwe na Womanentina ho.
Yebo papa na baso ni asaka kire na Kufuadu say o retain papa no 4 years.
Enwachi no ye kwanimu no enanananom ene wo manfo a wo mo ewo sienchem dia de sede atodwa se aban telecom mask bi esi ho a emmoa na wo mo enhwe se bi ombetimi ayi afiri ho emesremo wo mo chem se wo mo hia telecom mask a ebetimi aboa mo motimi dia ye adwuma ama nkitanwodie nso akoso awraho sem bi se abema wonye mfie du na ye fani Emmanuel wo se ekom ede no ena kubedua wakofruye akwada free ebeto fom a wo praye a yedidu ayresabia no na wo frim ensempi ka wo enum ho ene yede som sekase bo peace 104.3 FM so
na Oson's chemist and you read Oson's garlic capsules abeta yachi MTN everywhere you go. High Sense Ghana. Everyday prices for everyday people. JM Ado and Sons. Budget's organic apple cider vinegar and 1 plus 400. Duffy's Health and Beauty. One more energy or Hima Feminine Mixture. Abba Igaso. And you kwe and the cray moi. Yadeka sebono ebremo. I can go for Moti and Ghana Yumre Ayame. Nana Yaukesi.
Akosia ago aboaje Africa sebo no nsem no enie ene Supreme Court ekwansetina na Omampanyi dada His Excellency John Dramani Mahama a woye petitioner wode nasem sankwada court biem sa asem wo kan se watomu no wo pese wo bie eno ena lawyer chachichi kata wo no ena ye lead counsel ede ma no wogina apaso kirechiremu ede ntie sesa asem ne ma ho kwan no mu bie na wo mo hye ma mejen mensa no obegina dakam na wodi adanse eno na Supreme Court to say petitioner no asam na wode aba no nenyina so na wode eba no enyanyina so a ejina mraso eti so mo gitumu a enyeyie eti boa na sese mo ebotugo na wo chemu se atemuafo no gira ya mo gina ye nyina ne se oh my Ghana se de nhihye sitie no ye de emra na eye adwuma na enso lawyer chochichika tabiro obegina pamu no o kiremu se wo matemu a wo de eba no wo mo nyina wo mo conscience so na judicial oath so na so wo mo nyina wo madwene so na wo mo enyina so wo mu so ayese wo mu dia tenten ne be adwuma wo mu dwumadie mu na wo mu mfa emu aten nanso atemuafo nkono a na wo mu tie adwamu no esi so dua se asem o petitioner ne dia ba betudwa no a wo no e ka se chinchine atwaye ma no emie mu no ne nyina so a wo de ban ne emre bie ne ho a wo Ghana ha a ejina so na so se law and the rules of practice no eni ba bia enu nti wontimi nkasa ade a eni mre mu no yemfa nya adwuma emma enu nti ne nsem a wo de etudwa ene se ne omu chechemu ede bae no wo mo lawyer chachichi kata enya dwene na ne nsem bia no wo ka sa asede miscarriage of justice na atemu dwumadi asa eya chia no wo mo chemu se enya no kora efise ne nyina so a wo de bae no na enyina emrem.
Respondent and the second respondent also announced the closure of their respective cases and invited this court to determine the petition on the basis of the evidence the petitioner had adduced in this petition and their earlier preliminary objections that the petition discloses no reasonable cause of action. Counsel for the petitioner filed an application for leave to leave of court to reopen the petitioner's case by calling the chairperson of the first respondent to testify in her personal capacity through the process of subpoena and be treated as an adverse witness. In that application, counsel for the petitioner submitted that he was invoking the inherent jurisdiction of the court on account of there being no specific rule of court to support the application being urged on the court. In his supporting documentation, it was the position of counsel for the petitioner that the chairperson of the first respondent had sworn to affidavits in which he had made the positions to the effect that he would be available for cross-examination. According to counsel for petitioner, these were the positions or notes which the chairperson of the first respondent ought to be bound by. He submitted that in law, the statement that he was available for cross-examination was to be conclusively presumed against her under Section 26 of the Evidence Act 1975 NRCD 323, and this should form the basis on which the court should order her to testify as a witness for the petitioner. He submitted further that it was the intention of petitioner to call her as an adverse witness pursuant to Section 72 of the Evidence Act. Counsel for petitioner failed to indicate to the court the nature of the subpoena he intended to issue and what kind of testimony exactly he was expecting the chairperson of first respondent to bring to his aid in her personal capacity. It must be understood that under Order 38 Rule 10 Sub 1, the writ of subpoena a party may issue to invite a witness may be a subpoena ad testificandum to compel the witness to testify, or ad tecum to compel the party to produce documents in support of the party's case. Counsel for petitioner variously said that the chairperson of EC is to testify to the court on the truths behind the errors that the petitioner has outlined from her declaration in his petition, and also to account for how she conducted her constitutional duty as a returning officer for the presidential elections, particularly with the final collation of voting returns resulting in the Form 13 under CI 127. This application to reopen his case for the sole purpose of issuing a subpoena to the chairperson of the first respondent to appear and testify as an adverse witness for the petitioner after all the parties had closed their cases was dismissed because the court in its ruling and the review clarified that the application was not supported by any law or settled practice. As a policy court and the court whose decision must be followed by all courts, we set out in our decision of 16th February 2021 the settled boundaries that every court must comply with if called upon to exercise their discretion and allow a party to reopen their case for the admission of new evidence. They are in two broad areas as follows. One, would the evidence, if it had been presented during the trial, have had any influence on the result? Two, could the evidence have been obtained before or during the trial by the exercise of reasonable diligence? The review jurisdiction of the Supreme Court is properly invoked under Rule 54 of the Supreme Court Rules 1996 CI 16 and requires the satisfaction of two grounds. A, exceptional circumstances which have resulted in miscarriage of justice. B, discovery of a new and important matter or evidence which after the exercise of due diligence was not within the applicant's knowledge or could not be produced by him at the time that the decision was given. Counsel for petitioner has asserted that it amounts to a fundamental error for this court to A, fail to find that the first respondent depositions about being available for cross-examination should be conclusively presumed against her, such that she should be compelled to testify as a witness of the petitioner. He urges that this failure to properly construe Section 26 of NRCD 323 is a fundamental error of law. He also urges that this court's construction of adverse witness by relying on the definition contained in Black's Law Dictionary instead of Section 72 of Evidence Act constitutes another fundamental error. Third, he urges that by dismissing the petitioner's application to reopen his case for the sole purpose of calling the electoral commissioner as a witness of the petitioner, this court is shielding her and enabling her to evade cross-examination, contrary to a position she had deposed to earlier in the processes in this petition. It is the position of counsel for petitioner that the chairperson of first respondent is required to appear and testify to the truth of what happened in the election in dispute to account to the people of Ghana for her stewardship as the returning officer of the presidential election, for which she had issued a first declaration and corrected that declaration with a press release the next day. She was also required to clarify matters arising during the cross-examination of the petitioner's witnesses. We disagree with counsel for the petitioner on all these grounds, urging alleged fundamental errors as constituting exceptional circumstances. This is the court of law and not a forum for suppositions. It must be stated that courts of law administer justice in accordance with law and settled practice, and no court can afford to lose sight of this. Further, this is the highest and the last court of the land, and our decisions on the questions of law have binding effect on no other courts. That before this court accedes to any application that is not covered by statute, the rules of court, or known general principles of law applicable in this jurisdiction, this court must ensure that it's not opening a Pandora box that can become a stepping stone for abuse of court processes at other levels of the judicial system. The interest of justice is not only the interest of one party in the dispute, but must necessarily be an outcome arrived at through the proper balance of what the law has prescribed as the duties of the court to all parties and the duties of the parties to each other. Thus, when the court has to exercise discretion in an extraordinary situation, such as a party seeking to reopen his case after all parties have closed their cases, the court has to ensure that the discretion is consistent with statute, rules regulating procedure, principles of law, and settled practice of the courts. We have earlier in this ruling set out the guidelines that all courts must follow when determining applications for leave to reopen a party's case at any time after they had voluntarily closed their own case. Applicant has urged that this court failed to appreciate the import of Section 26 of the Evidence Act, NRCD 323. This submission is misconceived because we fully appreciated the submission of the petitioner's counsel, and found them wholly unsupported by any rule of law or rule of equity to which the conclusive presumptions is made subject. It is not the case, as urged by counsel for petitioner, that we allowed Order 38 Rules 3E5 of CI 47 as amended by CI 87 to take precedence over a substantive act of parliament. The Supreme Court reviewed the legal principles on the equitable doctrine of promissory estoppel that has been captured in Section 26 of the Evidence Act in the case of Clipper Leasing Corporation versus AG and Ghana Airways in liquidation, 2016, 100 GM, 1 Supreme Court. The holding of the court clarifies that for a statement to constitute conclusive presumption, it must be a statement of fact, and it must be clear, unequivocal, unambiguous, and unconditional. The promissor must have intended the promisee to act upon it, and the promisee must show that he acted on it and altered his position. Further, all the circumstances of the case will be taken into account in granting relief, and the usual maxims of equity will apply. From this premise, the first question to ask when the party alleges that a statement must be conclusively presumed against the maker of the statement is, was the promise clear, unequivocal, and unambiguous, and unconditional? Was the promise and the context of the promise such that the promisor intended the promisee to act upon it? Did the promisee show that he acted on it and altered his position? In the context of the case before us, we are satisfied that the depositions in issue cannot satisfy the minimum threshold of being clear, unequivocal, unambiguous, and unconditional undertakings of the first respondent hearing to defend itself in this suit. At the time the depositions were made, the first respondent had already given notice in its answer that it considered the suit as disclosing no reasonable course of action and had gone on to file its submissions with respect to that position. All three parties had filed their submissions on this point. We found this to be the most determinative factor, that these depositions cannot be construed as clear and unambiguous undertakings that could give rise to a conclusive presumption that the first respondent will be defending itself in this suit. Again, the depositions were made by the chairperson of the first respondent as a representative of a party in this suit, and not in her personal capacity as a party in the suit. The decision whether or not to testify in the suit could only be that of the commission and not hers. The decision whether or not to personally testify on behalf of the first respondent commission is also not available to the chairperson because he's not a party to this suit. Further, cross-examination is only possible if there is examination in chief. Thus, if the first respondent, which is an organization, decided after the petitioner closed his case not to defend itself, the statements made as part of an affidavit in opposition indicating the options the petitioner could exercise if the interrogatories and other applications were disallowed cannot be said to have been unambiguous undertakings to submit either the commission through the chairperson or any other officer to cross-examination in a suit that they had not offered testimony in chief. Counsel for applicant has also urged that this court failed to consider Section 72 of the Evidence Act, but rather relied on the definition in Black Law's Dictionary, and so the ruling and the review was per incuriam. We find no merit in this submission. Black's Law Dictionary is a respected and reputable source book for the bench and legal practitioners. Reference to law dictionaries is an accepted and respectable practice in common law jurisdictions, including Ghana. Furthermore, there's no inconsistency and contradiction between the definition in Black's Law Dictionary and Section 72 of the Evidence Act, as already determined by the Supreme Court. In Akan disease, Dodu and another, versus Akan and others, 2003-2004, one Supreme Court of Ghana Law Report, page 582. We are certified that it is the nature of testimony proffered by a witness that allows a court to categorize that witness as an adverse witness or hostile witness, and not the description of the witness as such. And so the submission that the witness was to testify as an adverse witness was no answer to the need to clarify the objective of seeking leave to reopen the case and call the chairperson or the first respondent as a witness of the petitioner. Section 72 of the Evidence Act provides 72(1). Subject to the discretion of the court in a civil action, a party or a person whose relationship to a party makes his interest substantially the same as a party may be called by any adverse party and examined as if on cross-examination at any time during the presentation of evidence by the party calling the witness. When such a witness is cross-examined by his own lawyer or by a party who is not adverse to the party with whom the witness is related, that examination is to be treated as if it was a re-examination. Clearly, the positive part of the provision in Section 72(1) is the fact that the person who calls such a witness has an interest that is adverse to that of the witness, and he is allowed to cross-examine the party he has called, and not that he merely described the witness as an adverse witness on the application to call the witness. In Ray Akan disease, Dodu and another versus Akan and others, Supra, the Supreme Court had the opportunity to review the distinction between an adverse witness and hostile witness. The court was clear that being an adverse or hostile does not arise from the description given by the party who called the witness, but the nature of testimony given by the witness. First, Dr. Sechu JNC had this to say in clarification on the general nature of witnesses and the specific nature of adverse and hostile witnesses at page 599. Quote, as a result of the testimony of the third plaintiff witness, namely that he did not see either the testator or the second plaintiff witness sign the will, counsel for the executors applied for permission to treat him as a hostile witness. Learned counsel for the defendants was right when he submitted that the witness should be rather treated as adverse witness and not as a hostile one. The reason is that any attesting witness will be a witness of the court and not that of the party calling him, end of quote. Professor Kluje JSC went on to state as follows from page 626 in his evaluation of when the witness is an adverse or hostile witness and the effect of the testimonies of the two types of witnesses. Quote, the trial judge, with the benefit of observing the witness, may choose to believe an adverse witness or part of his testimony. The fact that a witness called by a party gives an adverse or contradictory testimony does not lead to the irresistible conclusion that the adverse witness is an untruthful witness. The witness may be an adverse witness precisely because he insists on telling the truth rather than commit perjury in support of the fabricated story of the party who called him. Usually, it is difficult to determine whether the witness is merely adverse or hostile when there is no previous statement by him with which he could be confronted. In my view, a witness is a hostile witness if it can be shown that he knows the truth but deliberately persists in lying to the court. There may be different ways of arriving at that decision. End of quote. We do not see any fundamental error occasioned by this court's evaluation of whether the chairperson will be an adverse witness merely by her description as such by counsel for petitioner, even before she brings any testimony to the court. The issue that was determined by the ordinary bench is whether it is proper for the court to exercise judicial discretion and allow the petitioner to reopen his case for the sole purpose of calling the chairperson of the first respondent as his witness by the issue of his subpoena. Our determination was that it would not be a proper exercise of judicial discretion, and we do not see the miscarriage of justice that our decision occasioned, since petitioner continues to insist on not disclosing what new material the proposed witness is to testify on, and how that new evidence can change a judgment that is yet to be given. Counsel for petitioner also contends that the ruling was in breach of Articles 19, Clause 13, and 296, as it was unreasonable and irrational. Counsel for petitioner failed to draw the court's attention to any unfair exercise of judicial discretion exhibited by the Supreme Court against the petitioner, just because the court refused his application to reopen the case he had closed and to serve the subpoena on the EC to serve as an adverse witness. We would like to reiterate a time-honored principle of the adversarial system we operate, quoting the Supreme Court in Clipper leasing case, requisite evidence in his or her defense. The petitioner purported to present his full case in the witness statement submitted after the depositions in issue had been made. On the strength of those testimonies, including that of a third witness petitioner later called, respondents closed their respective cases. If the petitioner intended to rely on the depositions in issue, the law required him to state as part of the testimonies he would rely on the specific testimonies or documents he wanted the chairperson of the first respondent that petitioner has summoned before us to produce to aid the petitioner's case on the alleged strength of the depositions. As part of pre-trial processes, the parties and this court could have had the opportunity to tell me if truly the documents were not available in petitioner's custody, as happened in the application to produce originals of the polling station results, or the testimony sought was relevant to the settlement of the matters in controversy in this petition, as happened in the application to serve interrogatories. Statutes are construed and applied as a whole. No party or court may take part of a law and urge it to be applicable while ignoring the rest of the statute. Sections 10 to 14 of the Evidence Act lays down the burden of producing evidence and the burden of persuasion squarely on the party that alleges any position of fact or issue of law. Further, we stick to the time-honored principles that the Supreme Court has adopted in circumstances in which it reviews its decisions. Thus, in the case of Mechanical Lloyd Assembly Plant versus Nati, 1987-88 Ghana Law Report 598, page 603 to 604, and the DJS stated, quote, "Let me say at once that for all I know, virtually every judgment on this earth arrived at as a result of evidence gathered from several sources can be criticized. A Privy Council judgment put in the hands of any lawyer, along with the evidence grounding it, can be criticized in the same way as a High Court judgment can be. A person who has lost a case will almost instinctively feel that the judgment must be wrong. And why not? If he had won, the decision would be right. So if he lost, how could the court be right? But the mere fact that a judgment can be criticized is no ground for asking that it should be reviewed. The review jurisdiction is a special jurisdiction to be exercised in exceptional circumstances. It is not an appellate jurisdiction. It is a kind of jurisdiction held in reserve to be prayed in aid in exceptional situations when a fundamental and basic error may have inadvertently been committed by the court, which error must have occasioned a gross miscarriage of justice. The review jurisdiction is not intended as a try-on by a party after losing an appeal, nor is it an automatic next step from appeal. Neither is it meant to be resorted to as an emotional reaction to an unfavorable judgment. Secondly, in Chapel Hill vs. Attorney General and another 2010 Supreme Court of Ghana report, page 827 at 850, the Tibet JSC further set out the parameters for reviews as follows. Quote, I do not consider that this case deserves any lengthy treatment. I think that it represents a classic case of a losing party seeking to re-argue its appeal under the garb of a review application. It is important that this court should set its face against such endeavor in order to protect the integrity of the review process. This court has retreated several times without number that the review jurisdiction of this court is not an appellate jurisdiction, but a special one. Accordingly, an issue of law that has been canvassed before a bench of 5 and on which the court has made a determination cannot be revisited in a review application simply because the losing party does not agree with the determination. This, unfortunately, is the substance that the current application before this court is. End of quote. The application and the review was dismissed because it was not based on any known law or rules of practice. We dismiss the instant application as being wholly without merit.
As the court pleases, you are grateful to the court.
Any ye his lordship justice and in ye bois, one no ena echiremu na odiko wie yese petition na some or de ba yese asem ne yemiem ne yenkano ne nyina so a wode ba nyina enimrem Ghana nso ye de mra ena ye adwumanti na sese court ne gina so na wo mu sigina na no achi na court ne se nyame adomo atemu no ebeba so eye 4th March 2021 na ansa na ebeba so no wochina obia emfa na sem na ye written addresses no womo emfa ngukrata so no womo emfa meto na afei atemu no nso womo de aba ama eniema nyina nso etime akoyie na Supreme Court ho no a na former Deputy Attorney General aban lawyer panyina bedi echeda that Dr. Dominic Ayene wono nso ebepie court ho na womo kiremu se na sem bia wokoka yese atemuafo na dika for womo agene dada no na esese obeyi ne ho ano ewo court ho na no na Dr. Ayene ebegina mu no womo kiremu ene omode mrato to ho Akan yi an no na Chief Justice ene ne yebo a HM se wo biti se Dr. Ayene a emramu waben wo ye mranimu ni na waya Attorney General pen na wotimi kogina bonten ka asem bi ete saade a na asefem a entwa yie eti wo ni mansontwi bi a ba bi okogina ye no a wo ka asasam no a ensem fata no no won san kogina ho na won ka asasam no ana sei na Chief Justice Ekano.
Yes, I know the lead counsel was a president of the bar, but Attorney General, somebody who has acted as Attorney General, is the head of the bar, not the Bar Association president. And we want you to tell us whether you did say those words. Then you proceed from there.
My Lord Chief Justice, I did say those words. My attention was drawn to the fact that I might have crossed the line by Mr. Frank Davis. And Your Lordship, on the advice and consultation with my counsel, I have written to the court rendering an unqualified apology. I delivered that letter.
What we can do for your client is to let him go back and purge the contempt. Yes, he spoke to the whole world on television. Yes, he should tell the people that he's very, very sorry. What he did was wrong, and that is all. We are not going to find him. We are not going to give him a bond. But at least coming from somebody who has acted an Attorney General, if we don't take any action, it is going to send dangerous signals elsewhere. That is all what we want to do for him. So if he does it today, the court will assemble on Thursday and just strike out this matter. That is all. We are not exacting any serious punitive measures against him. All what we want to do is for your client who has confessed to whatever he did to he just go and apologize for the harm that he has caused to the profession and to the bench. This is our profession. Nobody can come from elsewhere to make it better. Yes, beyond the lawyers, nobody can come from elsewhere to make it better. Yes, we can make it. And it is a duty which has been imposed on us by our court.
Yeah, any ayeti ye Chief Justice eni ne yeboa na woka Dr. Dominic Ayene ho asem na owie ye sha mo hye no se ba bi okogina ye na woka asem no wonkoka enam so ama Bolga is mashebedwani Dr. Dominic Ayene ampa se de court ne hye no wo ye ne pepepe na moma ye ntie sane osi eka no.
I am here this evening in respect of the remarks that are made to you on the 16th of February after court proceedings. Those remarks were widely publicized by the media, and both mainstream and social media carried them and they went viral. I have looked at what I said that day, and I have come to the conclusion that I went overboard, I crossed the line with respect to the remarks that are made in terms of attributing impropriety to the Supreme Court of the Republic of Ghana. And I just wanted to let you know that this morning I delivered a letter to His Lordship, the Chief Justice, offering an unqualified apology to the court. Now that letter has been filed and the Chief Justice of the Republic has referred to it, I want to take the opportunity to read the content of that letter to you, and thereafter I will apologize and retract my words. Now, the letter reads, My Lord Chief Justice, summons to show cause unqualified apology to the Supreme Court. On the 16th day of February 2021 court, in respect of a ruling that the court had rendered on that day, I did so in my capacity as a member of the legal team of the petitioner, with instructions to brief the press on matters of concern to the petitioner after court proceedings. In carrying actions on previous occasions, repute, in the circumstances, I wish to apologize unreservedly to the court. Yours sincerely, Dr. Dominic Ayene, signed. And for those of you, I'm sure Mr. Frank Davis is not a stranger to the press. He's standing here to my right. I remember on the 16th of February when I finished addressing the press, he walked up to me and reminded me that the phrase that I had used, that there was a predetermined agenda, had crossed the line. And that is when I started thinking about whether or not I had crossed the line. And I agree absolutely with Mr. Frank Davis and those of you who think that I crossed the line on that day. I wish to unreservedly apologize to the court, that is the Supreme Court of the Republic of Ghana, as well as the justices in particular who sat on that day. There was no intention on my part to impugn their integrity. I was just expressing a sentiment with respect to the ruling of that day. And I want to render an unqualified apology and to retract the words that I used on that day in their entirety.
we Dr. Dominic Ayene, former Deputy Attorney General, was hired Mashebejani, Ewo Boliga East, and one switch your poyano, wo Bejina, what the chopper, or see I didn't cry a year crown, no lawyer Frank Davis, Muna was away, dear. Wakasama will touch them, my 10 sin one no. You wouldn't mumranunti or no answer what you two munti, no, I can't crouch or let a quada dada, and the Akoma Chief Justice said one Kasaye and Chaye. It's necessary Bejina, or Nakratana or Troyano, or King Kaima, we are seeing. Etibia and want some ena yeti nana
na yanko ahomano so na yene lawyer Chelebu Akodia lawyer TK UTV ade chensroma chiame enchuchu komo no ne see despite media name e was Supreme Court any sansemi ehu nyina lawyer majoy
ya ni o ya le se
erade adom na pacha so
ya me adom boko
you ya da se papa enti ma yan chance free baby a ya de wie sesi enti no say ya de sa contempt no eto so a ase ne say na edin de betimi aye eho asotwe
yo ya me da se idi kan ne say ya kan say contempt a chere eniema bia ina no yen ho ntiate enoye bi kasa bi enoye se waye bibi anansa wanye bibi na edi enimtiebu ebra court no nti se court ye ohye bi na se ohye no mpo se we ni so na eni so na we ni so ye fa ne se eye asoden a eno no na je se we bu court no enimtia no ebi se court wotumi nti ohye a ewo se ejina so wo ho asem kan ye okwan ye fa so ye ka no demo mpendo a wunyan ye untu anamo bia na bia na saade no wo se wudiso a wo se wudiso we diso a na je so bu court na limitia e bi so ne se waka kasa bi na egu court no ho efin anampo waka kasa bi kwa koye se bi court na ete ho no mpo emfa mra na ye adwuma na mo de bia ombo muslim ana se omo ye hwehwe animu a wuni nyina so bi a obetumi de akire etese de court na nim etwitwifo no so etumi eye en buma court no afi wo bi on twetwa court anamu dem fa ne se court bi dia odan se ni bi aba bi dia danse na kwa twetwa anamu se asem na wo di ni kuma na ngi no kwa mkura ne se bi ko mpo akota bi asem na wie no na ebia o dansi bi ko di anse na se o tata no eno so kura mi ko ye enintiebu e ma ko na twana mu e ma ko no na the dachi bi person share contempt ho asem pa ma menye recommendation book ya me book di betimi akwa ko bi ato no akenkan book no ye friend no due diligence of the law. There was due process of the law. Now me due diligence you may be in confirm. Due process of the law dealing a blue book or can't contempt one sempa. Now only be seen that the issue there. This is an year will be and son and baby winner. Say ya obekaya 2013. And same because so fast Supreme Court to ya my head be people buy. If you look at it to know. Ibimu kaseti ya atemuafo na yaka mu nyina abom ibimu se da yi atemuafo no bi no masopa wo de omo ka no enye se bi mpo a gina bibi a wagu so ase atemu na mu buo no ye ka bibi di akere se de omo di ade omo gina so de bu atan no enye mra ne mo bi kura mpo a eye ebusua bi omo bo ana se ku bi omo domunti yes ana emedi enyi nim ma court ni nyanim e woni panim elenti e ba na sa court no fa se wo gredintia na so chu de bia e wo ho asotwen so e wo ho enti enema e content na nkasa no e brenti amboketu e bi se e doso na e doso ma se to dem pa e contempt e be contempt e contempt wa wi ya ugunu enti na e bra yenu apani ayikotu okoko tani ko gina yenu asa John anam na memfa krensi no kan say ewura no yesem wa yin sem ma ba so amone abebo na nso so ansa mo nkai say emra e wo contempt ho no yen share da enche no efi yusu go focus no say ya arbitrary ema temuafo no ba akokura kan say on train sign bize sa asem arbitrary no nye kata sesen go kan ena oso ewura no mo chewnie mo ankasa na mribi na mo bu asem mo kan say the law on contempt no the case of Republic versus Tommy Thompson. Emma Sabre PM Penny and now to court Wiki, Justice Atuguba, Eka Ampa, Yokano, Sanity. Yampacho,
me wa hapa lawyer.
Aha, 18 Sana, yao, etchi contempt non Macano. The obey and now 1 year. Ebeya so de ama court na se wutwintwa court na mu na se wo de court na nim epipi form no court no se to court na nim a utimi chu de bia na wo ba sa na enye se ye ba be kire se bibi o afi na ye ba na ya bo ko egu na wo akọfa ho lawyer na lawyer so so atwe kra da bi etimi fro se be kire ni enti an se ye twe waso e wo na anu asem a wo kan yi mu ni wo ba se ye na wo ni be dikan bi so wo kan sa mpa na so asa mpa na di Akan so it so ba so nka ya it you kwa ba kire ti so be ka ya any 13 you know bi no ba ya no person mo chese ko nyesa na no mo kan no sa ba bi mpani da se tu ba ka sa o pesa asa ma kan ye bo man ti ana no so de bi de so nyesa na e kan no any ti ya o me ni se sa na ti generally no sa na contempt no e ye adwuma.
Okay. Enti ya the contempt no to enchen a ene
na ya we me so fache me say contempt no so no e ho aso twe bi ni say itimi kura do ko to afiase.
Okay.
Ana say itimi boka ana say ye ma wo de kunsa hye nsidi krata ase say sa de ya mi ni din system mi nye biem da ana say ye ma wo kona wo kodwira wo ho no ne say asam na okaye no okotwe san na wapachewo na wakase wahye bombu kura se asma mekan yi no menye sa biem enti enese utie yenu apani ya na ye frɛ ne yenu apani bi se court no kura kan ya se wo be ya attorney general ye so ye leader of the bar ya lawyer fo a wo Ghana na no una wo ye pani ye so na ye pani so na ye GBA president no de ono ya lawyer fo nka bomku president nemu attorney general de ono ya lawyer fo nyina pani na ye mra no ye nhye ne amambre mu no so wo ye lawyer yimpo a nka wasudie pa ne se una tigina wo ye una ye court no etiginafo ebise court no ni ano na sese bi ubi kan animu a ana ko ubi kan na ho asembone a waba be gina no enti nka wo pa nka lawyer fo kra de adwuma baako ene se nka ye mom ne ye bo court no ho ban na so be ye lawyer fo nyina peri ze yemia ya semi ya wo de wo waso de no kra no ya na eso enti na no mo kai no sa no toda lawyer umpempen so a wedu no kra no be ma ni hu se wo kra de ye mfa nsusu ti so be ka ya ye nua asadwo de de sei ya se tugu ba sheda kan ya o se ma te kra mpo kra se ye nua no mo te ha no e bibiri mo kra ho a o ye classmate na se ya mpani ampa sa de a na ye nsusu se lawyer na tifia ko nkan sa no onu mum de bibi sa be firi na mu aba na nsusu ne se o he a ye nua pani de o ye no na fekwa one court na antwe daire bia ye kan ya ape no so one ye o kan ye no na dwene kura ma so na ni nua o se ni nua no kura na o so otwe na dwene fi so no enye ni nua one no ebo oni ni nua one ni free maame ba ko politically o se ni nua o wo fa ba ko eye onua Frank Davis e na e twe na dwene si se mi nua asma o kan e de what trash here ene man ni ba no ho so o se na asma o be kan se court e nyina mbo ya TB ni ene man who say ene na matrashe de a na esese midwira me ho enti na o tro krata de ko ma PM pani so court no we di mo che wa ni asma na no me kan no ni bia ma dwene su se ma nkan yi eno kwasem ne se ya enye kasa asabio e wo se ye soso so o mamu ase se court di asem na yi bi ya no akase court no kra de o ba no wa na dwene dada if you say court ansa no be hye enhye bia no ana obebu ya asem no wo so di ugina so me the pastor Chief Justice away PM Penino, or can kind case be quotation be a womb. Ye be we are making kind. Ya minister no promise and the braille.
But I.
Aha, so I think so I quotation no, made an minimum, na imagine what say, making kind. And now, you know, you can far empty. And ya was only see, and you also, what kind of fair on the quarter nine. Quarter also in the air, you say, there be any side I am, and when I can't read it. Or cannibal call, was a side I said the Audi baby, a while consume now could be out. Now you cry and tinty, Yadi, I just won't be ever so. In I hear you, my boom. What tears my PM penny crackaya? Was it not you know cry dear? Now no cry a man was soon this way. Kona ko church said dear, why I fast where I am conform person school or I am no boom. And now said being a deputy attorney general, your committee be near could be no cry or net PM for even minutes as well. Into the middle in an idea a banner, sir. Why I'm trying to quarter also I'm trying to you won't say, Kona ko na bia we ya say ya woni so bia we ya ba nti nti ko bia wo ho na san fa wo ho be kire ya wa fie na je asam no yi a na ye ja na kwan kura na ekọ nti na ne e fa sa afem wo no de si ye no
na asam no po na nkasa so ene moko na mo sore so sen
ya so ni se asam no po de enye na na ye sha ase e sha ase free bra na do dan kwa akofo and electoral commission. I can't so much da John Dramani Mama small the other report no. Omar na dance ya ochu go krata so in a witness statement. Omar na dance for enu mu asem. Omar nsem we yi ya no. Omar mu dance na wi. Omar nyi ni se omar ho anu yi bia. Entinya ade a obeyi ya no. Ena owura chachikata ojire mu amama da se da bida. Muntumi nkasa munni ho kwan inimre musa ena PM for no kan say da bi o ni o tena momra e bi say no na ya gura ma ade ya afa e na da no kodanim ena court kan say momra no bia mekire mra kwan so ni nti a osusu say ni o se o ho kwan say o media dance say abre no o mekire na de o so no nso so o mpre ma ni bakro no ensign tuma be glu kwanti mfi me san akono o so emekire mra kura ogina so ya yina yini yeni tiata ajeche no umbegina haye ama ubia bebisa ne brofo ne mra woni etre ajajifo no sorry ya omko baaye no nada no 11th February so be kaya ena omodi omumu ya baaye se omahwehwe mremu ahuru se court ni tumi bia se omhye obi chechinchina obra no media dance enti na asem no popa ewumu no enti no omo ni nhye ne sa eno ne ba de enti no mo ye nhye se esan se electoral commission na ranko akufo ado so munti adanse na emra ma ho kwan na court no nim se emra ma ho kwan ne ene na omo pa mu aka se electoral commission ne na ranko akufo ado omo so omo close omo case omo wi omo asem ka na no na enkanhye ya aka no eba beto aso se ene na ye wi asem kan dia obi an control na dwene wa asem no aye friend say closing address no ana owu strategic kaka ogine mu mama pami da say ane me san so e the application go for aba na the order be there the all say court no ma kwan na ombie na asem no biem e say no so na asem no watum for closing the case on sign reopen the case na omfa ohye ento ma meje mensa so Akan na de na o se on benefit electoral commission say oni dance na ne dance ni abedi say there is a most electoral commission na NTV media dance ya na so media dance ya ene na ma meje mensa no gimbi ma pem no mai na ono mum emet na da kam na ye ndoto na no se no kwasem bi wo wa isusu se de ho na wa wo so beka court no etie aloya fo ni nyina se de nyina yehu no Ubia Bekan said you need a farm brown. Now, Omuvi and Ekano, and on the 16th of February, court no, if we are say, Omasha, Semunum, or when you say, a choir of Hossa, now, Paya Paswa, so we will case you now, the same be mountain. And your choir, a year fine a fight at a quine here. Quine here says a new choir at ye. Now, son, you will be power once. I face so crumble. One be sat a year already to get us. Say, and a family be a crown of palm. Mammy, I was so run on better or better now say, or a dance in the bay. And already to get at you, Musa, or Babet Musa, or a dance in near. Neho akoye wakoye obi a odi adanse a etia ne wafre no no ye be friend no kasa mu say adverse witness and as a hostile witness no na answer na court no ne danse o de ne mu aye ba no o churchiri mu okotu dictionary enti court no chiri mu say maami a wo so mra hostile witness no the what kind Black's law dictionary I know your dictionary be a lawyer for your dictionary no na the ninth edition and also say okay the definition no what you say sa adverse witness and hostile witness no onye dancing bi a sabi woni na ne baabi e na wo kwakofa number imo wo dancing a what na daka mu dada na what ya daka mu no o ka bi a itia wasam no nya say itia asam say ya turu anasa no kro Nemo mu na bi kura mpa o ka no kura bi a etia wo asam. I don't know what record we say say so na wudi na nyima na de na no kwaso ma to genti no. Say wadani etia o. Anya na court ma mem fa ne fe. Obi a wo tia me na mem to na no. Instead say we di na bi. Court no etia mu say obi mu kura anya ade a bi kan ne say wantumi antre kwan e fa so e bi case mu no. Anya ade a wetumi antre say bre we say ne bre obetimi bi mu sa emra no wantimi ni emra no so ena afizo so ma me no to kro mpa wo de wo so de na ba no enya ade a obetimi de no aba e wo sa akwan no so ama no ayi ni na court no chire mu aka say wo ba court na say wo say wo pe kwan say yimbi wo case bi mu a ena wo so wanda sa no we bi kan de wadanse nyina ba enya say wo de case bi no na wakwakofa ma meji mensa ba bi say yawo sa asem we yedi kan Canada nti na mebo bodo na ina poso na na no na owe jajikata ese onya ne ho ntiase because owe jajikata ba choba mi chire mu say o mampani fi say o mampani da e bi say ono no wo shi ne de bai nti no court nsan ehwe mu biem na woni say court ka say on hwe mu biem na che say review ho asem ne ye ka no na koye review so dia na enye nipa na na no motena asenso na no ebeye aba be ka ho na omaye mkron enti enne de no so motena ase no na utie sade osi kan na asem na o ba review a obote court na ti wati wo mrem wati wo share ye didi asem ana se court na nkasa mpokura it is be a wedi ni a she be a wash principles be a on one kata establish no court no ebuso na amantenchia abanafem eninti no e na wo san aba review no so wo ba review a de wo de ba ba kire no ana se di mpokura na wo ba review efisa danse bi ana asem bi esi ata abẹ na asa asem na esi na danse na wo so wo de ba no eye ade bi a na bre na wo asem na edikan no wo de ba no na eni ko afei na rekompe anambu film aba anything na wo be say so na nkasa abre no sa afo no wo ho a ana danse no wo ho a ebi atimu ya fo no nkomu mu ya nkosa de wubu ya he no court tie nsem nyina no muti alo ya fo no nyina no mo se de bi eniema edi so a etimi ma omo se sa omo adwen no enya de a petition applicant no watumi akire enti na no asem no mo kan ye no omo da so gina ho saa pepepe ni mo mbesan kura so eti mu biem enti omu tin ni nyina mu maako na omu bewie no e na obo ni nyina kofa e wo saa asem a e wo case bi a ye frɛ no mechanical lawyer na case no na say ya ben hawa enka ye mo ne top e wo ho nti bi tie o na say o ma me kwan dia
I court na ma kwa utimi kan
yo enka mini kan kana go fu na obetra ya be ki
Sɛ lawyer twi deɛ wana wote sɛ me kakra o. Ɛne saa mom deɛ. Anaasɛ wopɛ nso a yɛnyɛ ne sɛ honhonhon no hwie guo da no. Woka no brɔfo obiara bɛte ase ɔno ani kurom kasa mu.
And you also say a party for more communication for.
Aye.
And then it is about community.
I'm Kahausa.
And she gave it back to be answered on the cool custom.
And no.
Or say, let me say at once that for all I know, virtually every judgment on this earth arrived at as a result of evidence gathered from several sources can be criticized. A Privy Council judgment put in the hands of any lawyer, along with the evidence grounding it, can be criticized in the same way as a High Court judgment can be. A person who has lost a case will almost instinctively feel that the judgment must be wrong. And why not? If he had won, the decision would be right. So if he lost, how could the court be right? But the mere fact that a judgment can be criticized is no ground for asking that it should be reviewed. The review jurisdiction is a special jurisdiction to be exercised in exceptional circumstances. It is not an appellate jurisdiction. It is a kind of jurisdiction held in reserve to be prayed in aid in the exceptional situation where a fundamental and basic error may have inadvertently been committed by the court, which error must have occasioned a gross miscarriage of justice. The review jurisdiction is not intended as a try-on by a party after losing an appeal, nor is it an automatic next step from an appeal. Neither is it meant to be resorted to as an emotional reaction to an unfavorable judgment, unquote.
Uncle to be almost uncle to be at the the cost of Timafu or when you know, I say, Ubiat Nasam Cocotua, Udipimoa, and I Timono Ecoye pa Nemo Cotianoa. Oh, Uncle Ye, now almost I know one says, I never know. I know one.
Say, I wouldn't say interested in that judgment, yeah. They can't hear mechanical lawyer assembly development, but it's not. 1988 at the moment.
1988.
Aha.
Now check.
As a review. Or see the circumstances under which Supreme Court will review its own judgment. The mechanic will have said, what say? So, over review and turn up to better than agreement. Now, when you can't rest on my tea of them, and the court on this one, running in a baby, and you go with you. It also means so much also waiting on them, the tea on waiting and also no. And the attention abba, court and say, you who attend to our watch say, yes, say, mamma, I'm not a better one. Attention bend at the Abra war. In the court and say, on one yagging, into almost a somewhat green, said you now no more. Sabe peppers so, and now my canal has a wish we are some now. And you know, better on us night to say, so you mean in so you know. Baba Pepper and to me now, I do not a cobble.
Lana, and then you know, back on.
Yow, my boom, what they are say, Mr. Stino, Mr. Court, no step court, a bra me with you.
Okay.
Maybe I try. Also, the people who cry like Casta proceedings was by court.
By court.
You must be so cast who yet to go. Maybe I would need my Kuma. I know the many in the Asabia, they won't be my imagine say, the way people are going to back as a back and say, I quote.
No, but the name Pesamichran say, at the more phone sona, or Munedi as 70 anymore, Modada. And now, we know, and one quack here say, a team will be on their bar, a petition and a lawyer for 1 Tiasiano, o ma ko pese court no ansa nwene hu bio nti no ye de mienu be ba be ka ho ama o ma ko ye nkron ene na ye se mienu be na ba be ka ho ma na ye nkron na me bi sa free but se nya de opese oyi ano anye hwe
so ka se da Dr. Kwesa White ba no o dia dan no ni pa no kasa no mu ni o kasa no mu se se wu enti awon ba no mo hye no mo hye mask nti me hu
you enti court no sorry no senso
enti se am sa no de ai akwaso akura kan ma me dada ebi se enti kamu ba ko pena na e wo se on se na o wetu jikata se asema ye ba ye dia beto court ni mu yenye mu ya ye nti se ka se kwa akotwe ya address a ezi so ye kura na se sebi ye bu ya ye wofo enti no court no se dia tia kamu ni se obia mobodi anse ne written address no o de beba enti bi ni so mo de beba no dia tia kamu ba ko ene ya wada Dr. Aide dia no nso ne dia ho se nka se ni na nkata ho de wo se bia kamu pa bi mu a ene na da 4th March ana court no so de atemu na nkata no ebeba na ya so ni se sa atemu no ebeba ehyimu mienu ruling ba akushim enti no mi muso de mesi a kire no ense o ga kota de ne de nto so bi asemu no ebi se so be kaya respondents no raise preliminary objection said the CI 99 mo kwan se ye the petition bi bebo wa se wo susu se bi petition no eni nyina so ana enimu a ubetimi raise preliminary objection and answer wo ho asem bi ka usu se water court no ehwe na what free when ni manimu ya eye embremu ubetimi aye nsa na wo hwe answer electoral commission and another kwa file ya omunyina raise preliminary objection in the case of electoral commission crowd omoka ase nka court no hwe no won kana nka asem no kra no omontu ebre a ondi mpo omoka ase summary dismissal is a court no hwe na manimu ya na nka omontu entina nka wadi nka court no e do mo sem na ena nka court ye ne sa nka bi asem kra nka ni meduru bi abi sa after na do danko akofo adon so ono so or raise the grounds no e wo ne answer no obi a opese okenkan no ofa answers ni mi no obehu ena bra court every year case management we ya or settle down issues no of our first issue na issue A no or the star question number I whether or not the petition discloses any reasonable cause of action and all ye order no or they ensure first respondent and second respondent say omundi can file or legal submissions in respect of objection now where we preliminary objection no na fi o man benida danzo so omo so mfa omo response emra na owie no kan say court no de preliminary objection no ehun we aye no be share judgment no mu enti on the 4th of March nyame ya adom na say court no de the judgment ba within that judgment no you be hold the ruling in respect of the preliminary objection no nti ya obi sabe na me said the Akan ye na ebi mo bi tare say a lawyer for no be nya kwan aba na mo fa je me say me use that expression one of the grow e court na ni mu ana on the central na file o address bi a we be gina court ni na mo ba be ye oral mo ba keka mo ho asem me susu nim ye ebi na we die e manasa so me mu se court no e chese gina no nti so ebi aka mu kura mpo a na the 4th of March na court say or the judgment to the panel
ho no kakra me so mete se na timafo pani ka che lawyer jachuchi kata ne se wo so de fa address ne bra ye kan na se ye nti bibi ase a ye be frem na ma be chichiri
court no she den ya no ebi ya manasa manasa so a na ya fi yin se ni se bibi aka mu mu
de me kai de ni nyina na ejawa bobo so e de amayi ye da sepa o ene wada agya nwumre nso yo lawyer Chinebu Akodua lawyer TK ono ene osi despite media na mu e wo Supreme Court sa asem ne de ni nyina na wachechim na ya hye da gibre buru don hwere ba ko ye betra sie Supreme Court asem ya yenka bibi fufuro bi anka ho isan say yen no yenim say asodie dai so say esese e mamote de asi court pote ase yen mu aten wa ha nemo ye mawote ase a de asi ye no pote na wo agina so asi gina say anya say na tie de na ye sei nemo say anase say ni de wo wasem eno onye yen yasem ye de en say ye bema wo atem a esi ye pote no agina so afa ehun adwene
wie nana ye di omanfo adwenche no e ba se de ye kan ne court asem ni nti ebre no ekọ nanim nti momfa nche na sese ye tim nyina kama ye mfa sedama 21st clinic e ye sciatica expert na sciatica expert de 21st clinic no wo mo ye expert prekope wo mo aben wo mo no mo de bibidro ye adwuma wo ba ye be ye lab test ye de wato afidie so ye de to afidie so massage bi e san ye wo no wa be unsa ampa wo ba wiase ekoyie na ye wi a wo to ase ho na ntin na fa wo sirem e fa wo nanse wo nanketenkete ase ho nanso ho nyina no a e ho atechema no a wo ti pains wo ho no na ye to ase ama eno eye sciatica na sciatica expert no eye 21st clinic say the 21st clinic say wo mo abie wo mo branch baako e wo afie kuma number 9 I know wo mo chem say e ben number 9 post office no nti omanfo momodian say 21st clinic say the baby amuwo bia ye ben mo ye twen mo say be a ebetimi akoyi ama niema edimo na ye de osompa ama mo na modi adanse say eniema no koye nti mo amuwo afie kuma number 9 ho no a en na say takurade adesha mo takurade 21st clinic atoa mo ho etita adifo mo nyina monko afie kuma number 9 ebe number 9 post office no na sciatica expert 21st clinic osompa pa omode so omanfo wo sunyane kumase enkramia mia bebrez enkranza ne ade no se de takurade fo mo nso manya bi obese hu branch a ebe wo afre 0540311311 0540311311 sciatica expert eye 21st clinic time herbal center for womada woroma yeto mo so ne asore wo mo the time herbal mixture badwa so malaria etu asienti menkasa me malaria ba menum ato aduane nya me de mempese medidi me sore bia asa bonsam be boro me da bi sese de kenya wo ho eduro ebra ye wo mu ye duro ye soso yare so eye time herbal mixture eduro papa a wono mo ebetimi atu fever no ase ena KNG herbal capsules ne de me so fa sho botom e se wonya KNG herbal capsules no a ebe ye wodi padua no ho adwuma da bia na ho odin wonya immune support papa COVID-19 abresu ye nya agya ye ho enti KNG herbal capsules tie di ni biem KNG herbal capsules number no obetimi dia first time herbal center no eye 0244417669 eye 0244417669 National Road Safety Authority Arrive Alive campaign ye de ye adwuma ye mfa ekwaso jojo mranya adwuma driver for motofo obia enhye so obedi bibia so pepepe na beboa ma niema edimu Give us herbal capsules ye de Give us herbal center for de Give us co capsules aba na Give us co capsules no eye kokwa aduro papa se usisimu ya wo ya mo tim amaman niema bekoyi a na echese eye Give us co capsules na Give us P capsules aduro no bemma ememma monsore waka na monteki mo position bedroom ho monfa strategy nya adwuma eye Give us P capsules na bebo mo chidom bemma wo no oba etu kwan a wontimi mfa ne nkoduru wo de da bia wo je oba si kwantimfi da bia na oyere na niase na atata ne nsuo na wura ho enti eye Give us P capsules adro na ebeboa wo bemma rashes ajo bemma aboso bemma wo hunsuo nkoyie ni nyina eye Give us P capsules wo jonso a wo te yawo ememma dro papa eye mu yie sa wonu menno na wo sa de co capsules ne kan wo de ne agyayi abakade wudem Give us herbal center e was 0543 222470 0543 222470 and 0506 851135 0506 851135 Remy Foods for the Remy natural spices and a Remy rice about Remy rice and mo anunso de mo awudi ekoye wudi ye jollof wudi ye morning stew ne nyina e Remy rice na Remy natural spices ne de omanfo nim ye wo Remy jollof wo ho ye di Remy chicken, Remy goat, Remy jollof flavors ahodoɔ any Remy fish aba what the spice wo nam ɛde aduane ma no yɛ de Remy foods for yɛ da wɔn mo ase nana ɔmanfo adwenkyerɛ no ebiwie apurugu chakapama de a wɔde afa Facebook live ne sɛ gayism for lesbianism wɔn fo masɛm kɔ mfiri hɔ nkɔ na ayi yɛn nsoso so koraa ɛwɔ Ghana ha wɔn mpɛ baabi mfa koraa wɔn afɔ wɔn afofra ɛnyɛ Ghana ha na ɛma ho fɛfo wɔ ha body ayi soft pa wɔsɛ me wɔn yare Mohammed Ibrahim Al Hassan and was a good evening Peace FM me show live na was say okay the other two as Memphisia Veronica the day COVID-19 is real it yen na yen say yeah this safety protocols no ebeye juma na Chris Podia wodia ban say any political leader president or MP will support or purchase a more my imagine some will support homosexuality na moncho mo kra ansana ye twamo twede David Kaneshi was in an plus akosia and will say is equal to nako so we will win this case we Haile Selassie God was a future generation obia ban bia beje LGBT for no atomu no yem for mo born nche wo mo da ye kra enso so wo mo so Akismi Ebenezer Japan such be kwai and also mampani his excellency na adodan kwakufuado was see please opanyini ent na fie mankwada enwe nanka zana pache wo hu we and Teresa Nelson say Peace FM no size Emmanuel J was say emsa wo bechia na ya akona du me pacho oje wo so pa na ye nua Martin Jan wo say juso domre aba wo say in fact na ya kese ne akosu agwa boje moye the best me fa masa wo du bantama was wo mampani his excellency na adodan kwakufo de ye to aba na ye yi no wo bie ntimi intimidate obi a wo Ghana ha wa win one touch ye home so ye ba ye beto so.
Tune it in, turn it up,
Peace FM,
and rip off the knobs.
Nche amodi banu ye kam say Remy natural spices and so Remy rice ebo ye chidoms 21st clinic sciatica experts say woma du takra de afie kuma number 9 ho enti womanfo nyina takra de de hye mon sori ye na monko 21st clinic sciatica expert enti montena ho mayare enyi monipadua emoso wo bra sciatica expert 21st clinic ewo ho give us herbal center the give us co capsules any p capsules abedwa so kokwadro na P capsules no de memedru papa National Road Safety Authority say arrive alive campaign ye de adwuma ekwaso jojo hihye ebedimu time herbal center for at the time herbal mixture malaria tu ye nemu ada ho aduane ya dem fever aba COVID-19 abreso na so fever so nom time herbal mixture now we are now the KNG herbal capsules na de aboso etu wo ahotoso se bibia edimu kama wo mo ne boa Emma yedem adwenkyere eba na adwenkyere no memfa kakra bi wo YouTube despite media emra akwasi enyan was say is the NDC communication team going to apologize to the spokesperson of the second respondent was say wo nsem bi a wo mokekaye teacher constitution we am say and was say ebre no aso say judges no lawyer chachichi katani application wo mutu go office wo matomra ato agu no mo de adane grammar teacher Nana Kwadwo Opasco and was whether JDM and NDC wompe omampani his excellency Nana Adodankwa Akufo-Addo wono a na etwa so and George Saponsi JM lawyers was say enya grammar any eka we are talking about law was say enone oman foundation yenyi nto wo meka grammar Dr. Babazamo master planner junior Kentampo and also lawyer TK super ne update no unbiased and also Peace FM moya number 1 Aaron Edu UPS and also Peace FM news papa and also council for petitioner do they want progress at all or pa just one person mo come any man so person mo gina fa ko for send salifu kaso zonko no se cardinal be bold and tell Mr. Mahama and his NDC that they have a case. Don't we have the listeners should form our opinion? Be bold. One day, and I can't say anything. Or a judge and answer a lawyer. Azema Ventures Chronom.
Yes. You know, to now you are just on Kakwe.
I expect where they show one. Nabuzan said, Uncanam fan satisfying.
Why? I give you witness number 2 and man.
In his capacity as what?
The 3 years and then Yaman.
Oga Willie Enkawi and was the NDC ne candidate. I said the Opacha and say, one more assemno any in so. Memphis Safo Victoria and was from Lady Vicky Techimantano so. And was Takosia, do you know you are my mentor? Oh, sir, I always listen to you a lot. Yamin Shaw, any Safo Victoria, Lady Vicky Techimantano so. Menso me feel you pa anti. We me your mentor dia any na. Wonso ye me menti edina we eye omanfo adwenche kakra omde eba ya ye gina so de kase bona ba wie
nana ya kese mene
akosia ago abo gina nsan ye beko no ye na osons garlic capsules fo ase ye da woma se covid-19 abresu de mo amafa garlic dadaada no munnim de osons garlic capsules etime ye munnim de etime ye bresi center table so a ye memene na se yare ena ye tu ase no na MTN se bibia wa subscribe ana no subscription bia minim ba bi efire na tuetiem nam se content manager wo ha mefre star 175 hash wo disconnect kura na o ma send message wo disconnect kura na o ma send no o ma otetewo enu ntina MTN se ade bi wo kwa nyo na subscribe you who wan say you have been subscribed for another month. Enti dial star 175 hash star 175 hash na de wompe no na waye frim high sense wo the home appliances aba wo nim se bra e wo mi eye bra e denti wo mo niam no wo matete ni nyina so wo mo ton ebo ni nyina akọ ye de aye no fofofo high sense everyday prices for everyday people. JM Ado and Sons Borges organic apple cider vinegar wo sori no pa atremienu na de agu nsuo de mu no wanom woni covid-19 we fa bonkum na we ya fanifa wo ye ho aduro enti Borges organic apple cider vinegar sabre die wo bi ye ne ho aduro enti Borges organic apple cider vinegar bomodia sa no pa bia wo sori a na de bia sonsuom na wanom na de bia trimienu na detoxify ni pedua na ye wo kama na wasannom alpha folic acid no aka ho nka enkoka se wo mepe folic acid wo so wo pe alpha folic acid na nsunsunuo ye num no na nsunsu ye didie no na nsunsu ne namba bi gigi ye nsunsunu wo tumfo ne kwabrane enti wonya 1+400 na chese nsunsunu mu akoda bi wo ha suku otimu a wo hu ade nyina ye nsunsu no teacher ni ka wo se be wo hu ne wo mfa no eye ensonsono enti 1+400 wudru pharmacy ho a men kasa me pesunsunro kasa me pe 1+400 so what did you know 1+400 and na Borges organic apple cider vinegar supermarket and pharmacy bia obenya bi na alpha folic acid and nso bi ewo ho Duffy's Health and Beauty ya di ohima feminine mixture base oba bia will libido kwafom waba wa himfie aye dry waba wo bo nsa eniema nkoyi asade no wonsisi so waye ne ho bibi bia so dane ne ho and waba 2 days ade che no waba 3 days ohima feminine mixture no wadru ebe ye fine and na de dance feminine cleanse ne de dware ahimfie na da bia na ahimfie aye kama ehwo ate pampa boni bia na ekọ na wunya Duffy's Health Glow Duffy's Healthy Glow Shower Gel Duffy's Healthy Glow Shower Gel eno de wodi na wo bono mokwa enye yie na nso oben gigew na de dware na we de na ye fe Etu na mu a yesi abrochira bragana aden Duffy's Healthy Glow Shower Gel na ase de ofra America ba ye ncheye no ase de oti snow mo we de na ye fesa no Duffy's Healthy Glow Shower Gel East Legon ye wo Kumasi ye ben Pogas Furniture fra ye number no ebra wo pe ohima feminine mixture Duff's yensuso yedwumadie Duff's Feminine Cleanse and a Duffy's Healthy Glow Shower Gel for Duffy's Health and Beauty was 020-749-1414 020-749-1414 020-749-1414 Facebook and Instagram Duffy's Organics and so your special eyes natural mineral water bujunsu wono mano akoma to yem best point saving solution loans any best assurance wɔn de wɔn ntoma bɔ ano sɛ wopɛ sɛ woyɛ motor insurance sɛ yɛ third party anaasɛ comprehensive wobɛtumi ayɛ ɛwɔ best point savings and loans bi ɛbɛn wɔ baabi abɛto susu baabi a wode sika to a woda na wada ɛhɔ nso ɛyɛ best point savings and loans yɛne yɛde kaseɛbɔ yi so mmɔnummerɛ yi ɛyɛ me ako when can I nyam yo and I can see the nama and then they can be 90% 100%.
That's only some of had their own pass. We had don't do pass and just mama. No Saturday minute now we are my chief from hey eno ago me tia me na chika krebia no my chief from
na wo tia wo chia wo nto pizza na chicken wings ma
wo den sapan order so we pizza nya na mo se covid any local
and then lockdown aka pizza
ya so mo se any
na si edi na wo man e di we so afọ we ye di na kono
sa mini
pizza na chicken wings ye di na ko ye di fire nu
minim so resume
and yeah, for your information, for your announcement, my resume.
You any Saturday. Any Saturday.
There's one man no.
Saturday me ba nyame adoma me.
I will buy for pizza.
Ba who me nyame adoma de be ya.
Gidi e ho. I have for fruit juice kan natural fruit juice.
O de keka ne na ope no.
Pizza
200.
Chicken wings
300.
Natural fruit juice
100.
And one and where you 600.
Father 500.
And so okay, so we 200 and so we 300 and I will see 100. One obo.
Father any 10,000. O de 10,000. Why? You beton su account. And father o de 1,000 nti nyame adoma merchant abekra merchant be ya wada.
Ojine ya wada.
It do the Saturday. Why? E really nyambe.
Nti one say what to pizza no. Eya to the chicken pizza no mo chicken supreme.
Eno ya wada you de mate be ka ho.
No man sana e kan.
Yo mate. Chicken supreme. Yo, me dem ya mpe high.
And na chicken wo.
Me mpe high court me tango supreme court de. Yan ko ba da so.
We jane.
Anyway, we have da mu nyina.
Say and the platform be ba so.
Platform.
Me did say okay FM so oba power she spotter Vim lady. Ono so be fa na dwam gidi se sabre kra wasom wo ho na no nwotwe nso ye de the platform dwumadi no so
ba platform na kosia ye no lawyer ticket
okay
yeah exclusive one on one Supreme Court that's far the way she Supreme Court as be duru ye ene na de ba ko so anyame ya adom a se judgment no ba ya wade be na wotwe ai be ye ne say o say rulings here e be kra o say very extensive
I am say Chief Justice will church him
na Supreme Court say judgment nankasa mean say very loaded because emere visa judgment nankasa no preliminary objection bi o ho a respondents raise say asem no kra ni merit ma court no ntie won twam kra na court no say mon twen eno no yere judgment ba yere beka ho
okay
eti ano no hyem ansa na judgment nankasa so no esa hye ho eti akoso nyame adom no the judgment ne ba ye be fa no one by one you see yeah purpose ne say ye be say nipa hu say ye wo court of public opinion and your court of law and your court of morality
okay and also so ho
and also o miensa ho ti de o gidi no
and na de be
what do wasem be ko ho court to cross out wasem be ko e ho mra ne ye ka e ho brofo ne ye ka
and say what the court of public opinion and your man for street so and obi atimi kasa bi obi atimi kire na dwene na mum say what the court am kasa court of law
court of judicature na
e ho de ye mra
entinye de madwen ye me de mra na say e ye ka
ho no okay
and now pe court of morality
this all kwa sorry dem
and also kwa sorry dem kwa sorry dem ko ka morality
court of public opinion and court of public opinion there obi aye judge
obi nyansa che obi
omo tanko for omo bon wo mra nim omo bon wo court of law there no
necessary not say omo bon
e wo court make omo bon wo court there ni mo mra no
e betimi aba say onimpa ba aha no rules no na system of practice ni different
yeah try hagene
chaza won obi anim nyansa che obi
I say social media streets
I know yeah court of public opinion
okay
and a court of morality no so
and you are sorry them
and in them
name okay
them in
them and the Quran and the Bible no and the morality
good
and a court of law
and no yeah the law
eye
eneka awo na okwa St Augustine be ka kire say o si emra no e na ahihye dan we a edete ha sei court no a mete ha na me be ka me mra na kire wo no emra no kra na ama me kwan se me ntana ha na me nkanti de me ka wa ha no e na ye law nye de wudi free vie ba no
and ye dan de duru am bedi nkomo
eti on comment ye be nyame ya do na judgment na ba ko so e be yi no mako because ye person Ghana for tiase
now we show so obi an nani abre so person o temra na se obi o Supreme Court na de na ekoso no enye mra ne na hia no na dwenkyere
agosi anti ono so no ye be boa na ma na hu se baby ono no nam no ye court of public opinion ono de udi asema review ni ho I appeal bi ani ho
and ho so timi kire waju ni free
ono mi se obi a judge obi ani nyansa che obi a enti na mugum sa but the person oba court of law no de yebe boa na manahu
okay
nti sa ne yebe ye no la tike nyame adom won kwan isu de yebe ye ne sa nti ene the platform en la tike na ebebo enkomo kada masia mamumu anitia adehye.
Tune it in, turn it up,
Peace FM,
and rip off the knob.